Selling digital products is one of the easiest businesses to run until the legal stuff is the reason you have to issue a refund, you get a complaint, or you have to pull it down. But the good news is most digital product legal problems aren't dramatic. They come from a handful of boring pages and checkout steps that you can easily fix. So in this video, I'm going to walk you through a clean, practical checklist for what you need on your site and your checkout to confidently sell digital products. And I'm going to do it without the fear mongering. So hi, I'm Liz Stapleton. I'm an attorney turned online business owner, and I help bloggers, creators, course creators, and digital product sellers legally protect their businesses without the overwhelm. Now, I do want to note that this video is meant for educational purposes only. It is not legal advice. If you need legal advice, you should seek out an attorney in your jurisdiction. So my hope is that by the end, you will know what to set up, what to double check, and the fastest minimum viable legal setup for a digital product business. So let's first talk about what legally sell actually means. When you sell a digital product, you're forming a contract with your buyer. And that means two things. You need clear terms for what they're buying and how it works, and you need marketing and checkout steps that don't mislead people. So most issues come from a mismatch between what your customer thought they were buying and what your policies and product delivery actually say. So we're going to fix the mismatch. So that starts with some non-negotiables. Your checkout must have a real agreement. Okay, this is a part that is easily overlooked. Some checkouts have this like automatically set up. Others you have to make sure you enable it. So if you want your terms and policies to actually matter, then your checkout needs to do two simple things. First, you need to link to your terms and policies in a way people can easily access. This means links to your terms, your refund policy, and your privacy policy. You also want to make sure you have clear terms acceptance. The cleanest setup is a checkbox that says something like, I agree to the terms and refund policy. And the checkbox should be required in order for them to successfully check out. Because if you never actually presented the terms and you never got agreement, it's a lot harder to be able to rely on them later. So what should your terms cover for digital products? Here's kind of a quick list. First, you need to cover what the customer gets. What are the deliverables? How delivery works? Is it a download? Is it a course portal access? Is it email delivery? The license they're getting with their purchase. They're not, going to be able to own this product and sell it as their own, unless maybe they are. Maybe you do PLR, right? So you need to share what they are and aren't allowed to do with your products. And any support expectations, how they can contact support, what support hours are if need be, and what your refund rules are, and what constitutes a product as being delivered. Which brings us to refunds and chargebacks. So we mentioned making your policy matter, and that requires agreement. But you need your refund policy to actually exist and be clear. A refund policy is not just about being strict. It's about preventing misunderstandings and reducing chargebacks. A solid digital product refund policy usually includes the window of how long the refund policy is open, when the window starts, is it from the purchase date, the access date, right? If you're pre-selling something, that can matter. And then what happens after they access or download, and how they need to request a refund. And that has been changing a lot in the landscape with the click to cancel from FTC, which in 2025 was basically made non-existent due to procedural grounds, though the FTC has since indicated that they're going to pursue the rule again, and many states have enacted similar click to cancel rules. Basically, it's just saying that if someone wants to cancel something, it needs to be as easy as it was to sign up. They shouldn't have to jump on a call with you if they didn't have to jump on a call with you to buy the product. And then as a practical tip, your refund policy should be easily available in three places: your sales page, your checkout page, and the receipt email is also one that not everyone does, but it's a great place to just kind of really hone in on, hey, this is what the policy is. And that can reduce a lot of disputes. Now, from a high level, I do want to touch on the EU's right to withdrawal rule that takes effect in June 2026. Basically, if you sell to consumers internationally, some places have cooling off concepts for distance sales, which means online sales. And basically what it's saying is clear terms and clear checkout language matter. If you're selling broadly, you may need to get some additional legal advice. But the way the right to withdraw rule out of the EU is reading is if you aren't targeting EU customers, so you're not actively trying to sell to them by either doing ads that run to the people in the EU or listing your product in euros or other languages, then you may not be required to meet the right of withdrawal rules. That being said, if you are required, they are very specific, and it requires people to it doesn't mean you can't have a no refund policy, but that's only available for digital products. It's not available for subscriptions. And you have to be very clear and upfront. People have to consent to that no refund policy prior to purchasing. It has to be its own separate consent. It can't be pre-checked. And you need to reiterate that they consented on the invoice itself. So there's some very specific language required. So moving along to sort of the FTC, which is the Federal Trade Commission here in the US, and marketing compliance. So this section is kind of what keeps you out of trouble without making you feel paranoid. So testimonials and results claims. If you use testimonials, make sure you're not implying guaranteed results. Instead of you will, use, you can, and add context. If you're sharing income or transformation claims, you want to be extra careful and likely include a disclaimer. You basically want to ensure that, what's being displayed as possible is like a general result. And if it isn't like everyone gets that result, you need to have a disclaimer. You should also note that if you're using testimonial disclaimers, if you incentivize people to give you those disclaimers, that also needs to be disclosed on the disclaimer itself, or on the testimonial itself. Now for affiliate disclosures, if you're earning money from links you share, even within a digital product, maybe it's an ebook or something, you're referencing a tool, you're going to want to make sure that the affiliate program you're a part of allows you to share your links inside that content. For a long time, like Amazon didn't let you share links in email, but then that changed. So you just kind of want to be aware of the affiliate program's rules and where you are and are not allowed to share your links. So you also want to make sure you're disclosing any affiliate links. Next up, privacy and data basics. If your checkout collects customer data, which generally it needs to, and especially if you're using email marketing, you need to make sure you have a privacy policy and that you are complying with the different privacy policy rules. Generally speaking, someone buying a product is not equaling to consent to receive marketing materials. Now, what rules apply to you and, what thresholds you have to meet before those rules apply vary greatly depending on where you're located. But if you want to just kind of minimum baseline, make sure you're good, then I would kind of adhere to the strictest rules out there. I like to say if you are complying with GDPR, you're in really good shape for pretty much all the other rules that have been coming out. There are several US states that have their own data privacy rules that are very similar to kind of the requirements of GDPR. Now, I'm not going to turn this into a massive compliance lecture. I do just want to make sure that you have a privacy policy that matches what you do and a basic understanding of what tools are collecting data and under what level of consent. Now, if you're collecting an email address, you're probably doing it because that's how you're going to deliver a digital product. And so you kind of have to require the consent you're getting it is under a contractual obligation to deliver the product. But that doesn't mean you have consent to send them marketing emails. That doesn't mean you can't ask for that consent. You absolutely can. There's different ways to do that. But at a basic kind of understanding, make sure you have a privacy policy and it is accurate in the tools you're using and the data you are collecting. Review it regularly. Our tech stack changes, which means your privacy policy needs to change as well. Next up is IP and licensing. So this is a part that can surprise some people, but if you're selling a template, a Canva design, maybe it's a Notion template, a spreadsheet, anything like that, you need to make sure not only that you're clear in terms of the licensing you're providing your customers, but that you have the appropriate licensing to be selling these products. So you need to make sure you have the proper licensing rights to the fonts, photos, and assets you're including. And your license terms you need to make sure they're clear of personal use versus commercial use and what people can and cannot do with it. And that you're not packaging up trademarked brand assets and reselling them. So a lot of legal problems with digital products can actually often be licensing problems. So just be aware of what you are and aren't allowed to do with stuff with tools you're using to create products, and then make sure you're clear on what your customers can and can't do with the products you create. So if you want a simple checklist, here it is, okay? This is the minimum viable legal setup for digital products. Terms. You need to make sure you have terms and conditions or terms of use with digital product license language included. You want to make sure you have a very clear refund and cancellation policy, that your disclaimers match your niche, that you're using FTC disclosures where applicable, that you have a solid privacy policy that is up to date and stays up to date, and that people are required to agree to your terms in order to successfully check out. That's what makes them enforceable later as part of your contract with your customer. And then you also want to make sure you have clear delivery language and your receipt email. If you do those things, you're going to eliminate the majority of preventable problems. So if you're watching this and thinking, okay, I've been winging it, you're not alone and you're not behind. You just need a clean baseline. And if you're not sure whether your business is missing something important, I created a free guide that walks you through the 5 most common legal blind spots online entrepreneurs overlook. And I will be sure to include that link in the description below. If you want a follow-up video, tell me what you sell, templates, courses, coaching, and I can maybe do a deeper dive into the most common legal gaps for that specific kind of business. Thanks for watching, and subscribe if you want to see more.